morning.
Court is in session. You may be seated.
The matter before us at hand is scheduled for arraignment Commonwealth versus Bradford Casler, 2016 441. Counsel, if you could please identify yourselves for the record and who you represent, please.
Good morning, Mr. Magistrate. Chris Tam for the Commonwealth. With me is Assistant District Attorney Missy Bain.
Good morning.
Good morning, Mr. Magistrate. My name is David Meyer on behalf of the defendant, Bradford Casler.
Good morning, Mr. Casler. Good morning.
Good morning.
Stand for the record.
Good morning.
56A does not apply.
That's correct.
Arraignment may proceed.
Okay, so the Commonwealth versus Bradford Casler on indictment number 2016 441. Count 1, charging motor vehicle homicide. Count 2, charging motor vehicle homicide. And count 3, charging operating the motor vehicle to endanger. Mr. Casler, at this time, do you waive the complete and formal reading to each of these indictments?
Yes, sir.
Yes, sir.
How do you plead, sir? Guilty or not guilty?
Not guilty.
Commonwealth question of bail to this defendant.
Yes, the Commonwealth does have a request for bail in this case. The Commonwealth requests that the court impose bail in the amount of $10,000 cash with the condition that the defendant not drive a motor vehicle during the pendency of this case. The defendant's driver's license is currently in revoked status, so we'd ask the court to impose that condition in addition to the cash bail. The Commonwealth feels that based on the nature and circumstances of this case that a $10,000 cash bail is reasonable and appropriate. Essentially, Mr. Magistrate, on March 1st, 2016, approximately 6 o'clock in the evening, this defendant was operating his motor vehicle on Chestnut Street, a public way in the town of Newton, the city of Newton. He was approaching a busy intersection at the intersection of Chestnut Street and Washington Street. He was operating his vehicle at a high rate of speed. Upon approaching the intersection, one witness described the vehicle, the defendant's vehicle, as accelerating with the engine revving at its highest RPMs. Another witness described feeling a wind or a swoosh feeling as she is seated in her car as the defendant's vehicle passed her. No witness at the scene observed the defendant's brake lights illuminate or the sound of the car, the horn on his car. Essentially, the defendant accelerated through the intersection at Washington Street, through a red light, clipped 2 vehicles, and then drove straight into the Sweet Tomatoes restaurant. Persons inside had virtually no warning of the impending collision, and as a result, 2 people were killed and 7 people were very seriously injured. The Commonwealth recognizes that Mr. Casler has multiple sclerosis. The Commonwealth did an intensive investigation with result to Mr. Casler's disease, and we have found that multiple sclerosis was not the cause of this crash. We believe that it had Mr. Casler was not suffering any episode related to multiple sclerosis, any flare-up related to his disease at the time of the crash. It's the mere fact that he has multiple sclerosis that the Commonwealth conducted the intensive investigation as it regards to his disease. The defendant's vehicle was examined by a master mechanic from the state police, as well as an engineer from the Volkswagen Corporation. Both came to the conclusion that Mr. Casler's vehicle was fully functioning. At the time, that would include the braking system was fully functioning, as well as the accelerator on his vehicle was fully and appropriately functioning. The Commonwealth recognizes that Mr. Casler appeared on his own today. This case, based on its nature and its circumstances, involves many victims, many people who have a stake in the outcome of this case, many people who have an interest in the outcome of this case. And for that reason, we would like to assure Mr. Casler's appearance at trial and believe that a $10,000 cash bail is appropriate. Thank you.
Mr. Tam, so he's here on a summons?
Yes.
Mr. Meyer.
Thank you, thank you, Mr. Magistrate, for the opportunity to be heard briefly. First of all, Mr. Casler, as he has from day one, recognizes that this is a horrible, horrendous tragedy. This was a terrifying event. Make no mistake about it, and Mr. Casler recognizes that every single day of his life. He has nothing but sadness and sorrow for the harm that was caused to the victim's family, and that community in Newton. That said, Mr. Magistrate, as the court is well aware, this incident, this tragic accident, respectfully, occurred on March 1st of this year. We're before the court today on September 19th, some 9 months later, or 6 months later. That said, Mr. Casler, Mr. Magistrate, is 55 years old. He has 3 children, aged 21, 23, and 27, all of whom are either in college or college graduates. Mr. Casler has no prior involvement in the criminal justice system. He was born in Newton. He was raised in Newton. He left Newton briefly to attend Ithaca College. He returned to Newton. He obtained an MBA from Suffolk University, and he returned to Newton, where he lived with his wife for many years when they raised their 3 children. As of today, 55 years later, Mr. Casler continues to reside in Newton with his elderly mother, who's in her 80s and quite frankly very ill. As Mr. Tarrant suggested, Mr. Casler does suffer from multiple sclerosis. He was diagnosed at about the age of 28, and for the past 27 years he has been receiving regular treatment to combat the effects of multiple sclerosis. Those treatments, Your Honor, respectfully, as to the question of bail, include not only daily injections but monthly intravenous infusions at local hospitals, where he goes for approximately 3 to 4 hours. Mr. Casler, most respectfully, Judge, has absolutely no incentive whatsoever to flee. As the magistrate notes, this incident occurred in March of 2016. Mr. Casler retained counsel. That counsel, myself and Ms. Thompson, have been in touch and frequent contact with the prosecutors in this case. There have been correspondence, there have been telephone calls, there has been frequent correspondence throughout the spring, throughout the summer, throughout the fall. Mr. Casler hasn't gone anywhere. He's received his daily, if not monthly, injections and IV treatment to combat the effects of multiple sclerosis. On the morning after this incident, on March 2nd of this year, he received a notice from the registry immediately and effectively revoking his right to drive. He has not driven a car since he was taken from that scene on March 1st, and he will likely never drive again. With respect to the question of bail, most respectfully, I received a call on behalf, or from Mr. Tarrant on behalf of the Commonwealth, informing me, as I expected, and more importantly as Mr. Casler expected, that a grand jury had returned 3 indictments in this case about 2 weeks ago. Mr. Tarrant informed me, as the clerk just read, that 2 of those indictments charged Mr. Casler with the misdemeanor offense of motor vehicle homicide by negligence. As the court well knows, that is not a felony, nor is there any mandatory minimum sentence that a court must impose if and when Mr. Casler either accepts responsibilities for his actions by means of a plea or goes to trial. That said, Judge, Mr. Tarrant and I discussed most candidly a convenient arraignment date. I got on the phone. I called Mr. Casler. I told him that the Commonwealth and I had agreed, subject to the court's approval, for today, Monday, September 19th. Frankly, no notice was sent by the District Attorney's Office. No summons was issued by the court, because Mr. Tarrant took me at my word that Mr. Casler would be here. And quite frankly, I told Mr. Tarrant, and he honored my statement that Mr. Casler would be here. Today, Mr. Casler appears before Your Honor voluntarily, no process having issued, having quite frankly known that this day was going to come. Most respectfully, Mr. Magistrate, I suggest to the court that Mr. Casler has absolutely no incentive, no reason to flee. He's here with retained counsel. He's been standing by for the last 6 months, waiting for this day. He knew ultimately he would be charged. He understands and appreciates the seriousness of these charges, but he has absolutely no reason not to be here. And I suggest to the court that based upon the Massachusetts bail statute, that the reasonable thing to do based upon the facts, based upon the law, based upon Mr. Casler's personal history, his family history, his roots in the Newton community for some 55 years, and his medical condition, that imposing $10,000 bail, most respectfully, is simply a punitive measure. That he is going to be here, he's here voluntarily, and that certainly bail of personal recognizance with a continued condition which was imposed 6 months ago by the Registry of Motor Vehicles, that he not drive, and certainly ensure that Mr. Casler is here for every court proceeding. Thank you.
Mr. Tarrant, anything further?
No, thank you.
No? Do both of you agree with regard to the standard as to whether the standard I'm supposed to judge on is based upon defendants appearing ongoing throughout the process, right?
Yes.
Mr. Meyer?
Yes, Your Honor.
Sidebar. So with regard, I also received the, Mr. Meyer's motion to impound the statement of the case. Under the new standards, that has to go before a judge, and at the sidebar, the agreement was also receive the Commonwealth statement of the case, is for both parties to have an opportunity to brief that and argue before the court at 11 a.m. on Thursday. Okay. So, and not to thwart Mr. Meyer's request, I am temporarily impounding it subject to that hearing. Pretrial conference date.
Could Mr. Collins suggest a date 3 weeks out?
October 13th, Thursday?
It's fine.
That works.
That'll be at 9 a.m. Counsel.
Would you say that's the 13th?
Mr. Casler, it is ordered by the court that you recognize the Commonwealth of Massachusetts personally for each future appearance before the court. Failure to appear at any court date may result in a $50,000 fine, 5 years in the state prison, or 2.5 years in the House of Correction. Further, while released on your own recognizance, if crimes are committed, the bail could be revoked and you could be held without bail. Mr. Casler, do you understand the bail warning?
Yes, sir.
Also, as condition of bail, you are not to drive any motor vehicles. Do you understand?
Yes, sir.
The matter is continued by agreement until September 22nd at 11 a.m. for the impound hearing, and further rescheduled till October 13th for pretrial conference. Counsel, if you have your client, report your probation is under.
I shall.
Thank you.